The U.S. Supreme Court announced Thursday that it has agreed to hear a case next term that could upend election laws across the country with the potential endorsement of a fringe legal theory about how much power state legislatures have over the running of congressional and presidential elections. The case, called Moore v. Harper, is centered on newly drawn maps of voting districts for North Carolina's 14 seats in the next U.S. House of Representatives. Republican state lawmakers want to resurrect a map that North Carolina's state courts struck down, finding that the map approved by the GOP-controlled legislature violated multiple provisions in the state's constitution by giving Republican candidates an unfair advantage through partisan gerrymandering. A court-drawn map has been put in place instead for this year's midterm elections. In their appeal to the U.S. Supreme Court, however, the Republican lawmakers argue that the U.S. Constitution's Electors Clause gives state legislatures the power to determine how congressional elections are conducted without any checks and balances from state constitutions or state courts. Based on this independent state legislature theory, they contend that the North Carolina state court's decision to throw out and replace the legislature-drawn map violates the federal constitution, an argument that radically departs from the U.S. Supreme Court's historical record of deferring to stop. The High Court declined in March to weigh in on an emergency request for this case, but in a dissenting opinion, three of the court's conservatives, Justices Samuel Alito, Neil Gorsuch and Clarence Thomas, signaled they would likely side with the Republican lawmakers' embrace of this theory. Many legal scholars, however, have been waving warning signs that the High Court's endorsement of the theory could have severe consequences across the country for congressional and presidential elections. It would be extremely disruptive, says Carolyn Shapiro, a law professor and founder and Cody. It would allow the possibility that people who don't like state Supreme Court rulings that have been on the books potentially for years could step back and then say, well, actually, that ruling only applies to state elections. Under this theory, Shapiro adds, holding elections for different levels of. Vikram Amar, Dean of the University of Illinois College of Law, notes that a hypercharged version of the theory pointing to the Electors Clause of the U.S.